one hearing stream 10. The next submitter that we have, and welcome to you all online, is for Kiwi Rail. Ms. Heffelthwaite, Ms. Grinlinton Hancock, and Mr. Childs. Welcome.
Good afternoon, Commissioners. Can you hear me?
We can, thank you.
Also I am Lauren Rapley, Legal Counsel for Kiwi Rail, also appearing alongside Kiwi Rail's witnesses this afternoon. We have pre-circulated Kiwi Rail's legal submissions, and if the Commissioners have had the opportunity to review those, I don't propose to go through them in any detail, but rather just speak to some of the key points, if that assists.
The submission or evidence.
Okay.
Do you want to just cover off the high points on those, please?
Yes, absolutely. That's very much what I intend to do. So essentially, the Wairarapa line is a critical freight and passenger line throughout the region. And you'll hear evidence from Ms. Grinlinton Hancock this afternoon about how this is essentially a busy line with volumes also projected to grow into the future as demand for rail grows. The Wairarapa line, as Ms. Grinlinton Hancock will also explain, is critical to support the overall resilience of the rail network in the event the North Island main trunk line is closed. The rail network generates noise and vibration effects, which, despite Kiwi Rail's efforts, cannot be internalised, and that has the potential to adversely affect living conditions and result in reverse sensitivity effects. I won't address that in any detail, but draw the panel to paragraphs 2.2 to 2.6 of my submissions, where I set out the legal position on reverse sensitivity effects. But effectively what this means is that the interface between rail and urban development needs to be carefully managed, and Kiwi Rail has proposed pragmatic and appropriate, in my submission, planning provisions to do exactly that. Specifically, Kiwi Rail seeks a rail corridor noise control overlay within 100 metres of the rail corridor, with land use controls on new and altered sensitive noise sensitive activities, and a rail vibration alert area overlay, which is effectively an information-only layer. The Council reporting officer does not support either overlay, citing primarily, in her view, the low volume of trains and noise levels on the Wairarapa line as the reason for rejecting the provisions. That is not the evidence of Kiwi Rail. Ms. Grinlinton Hancock's evidence is that there are train movements here that justify controls, and similarly, Dr. Charles' evidence is that the noise levels warrant controls. It's also important to acknowledge in my submission that the Council's own noise expert, Mr. Arden, does not object to the inclusion of land use controls on noise-sensitive activities, although he has a different view to Dr. Charles on the distance over which those controls should apply. And it's our submission that Dr. Charles' evidence should be preferred. The Council reporting officer also considers that while the movements might increase in the future, it would be more appropriate to address that at a future district plan review. And that was a Council reporting officer's position in the summary statement that was circulated late last week. Kiwi Rail's position in my submission is that the provisions are warranted now, and that it is not appropriate to effectively kick the can down the road to a future planning process, which could be another 10 or who knows how many years more, depending on what happens with the Resource Management Act reform. In my submission, we should not be waiting to some future planning process to protect the rail corridor, which is a critical asset of regional and national significance. Instead, we should be proactively planning for the future and including appropriate land use controls in the proposed plan now. We otherwise run the risk of poor planning outcomes, unhealthy living environments, and risks of constraints being imposed on the operation of the rail corridor. The other key reason the Council officer recommends rejecting the controls is that the costs, in her view, do not outweigh the benefits. I respectfully disagree in my submission and remind the panel when thinking about the costs here of Ms. Heffelthwaite's evidence, which is to look at the costs in terms of the controls and where they actually bite. That is to say, it's not a cost to every site within 100 metres of the rail corridor, but effectively only where new sensitive activities are developed or existing activities are altered. Turning now to KiwiRail's Rail Vibration Alert Area Overlay, which I addressed from paragraph 4.1 of my submissions. It's important to highlight that Dr. Charles' evidence is that there should be land use controls to manage vibration effects. However, that's not what KiwiRail is seeking here. KiwiRail seeks an alert layer to 60 metres from the rail corridor, and that does not include any controls. It essentially just provides a signal to landowners that there will be higher levels of vibration. The Council's reporting officer has questioned the need for the vibration alert layer, given it is only for information purposes only. The suggestion seems to be that it doesn't do enough because there are no controls on development within that area, and I respectfully disagree in my submission. It's more than just notice that there is a rail corridor in proximity to a property. It's specific notice that there will be vibration experienced in this area, which prompts landowners to consider those effects when building in this location. It does require a planning response, and we should not, in my submission, assume that people will undertake development with vibration effects in mind if there is not an alert layer in place. These layers, as the panel may be aware, are common planning tools, and you see them in other infrastructure scenarios, including the aircraft noise notification area for Auckland Airport and the Auckland Unitary Plan. And also rail noise vibration alert layers have been approved by the Environment Court in other districts as effective and appropriate tools. The benefits of including the layer in my submission outweigh the costs, and it's difficult to see what objection the Council has to this information layer. In my submission, the provisions put forward by Ms. Heffelthwaite should be adopted in the proposed plan. Those are the key points that I proposed to speak to briefly. Unless there's any questions from the panel, I will otherwise move to call KiwiRail's first witness.
Before we move on, Ms. Rapley, thank you for that. Could you please email your speaking notes to the hearings administrator so we all have a copy, so the panel has a copy of those?
Absolutely, we can do that after that. No problem.
Any questions for Ms. Rapley?
Possibly.
Sorry, we're just.
Sorry, just.
No, that's just not me.
Sorry. Okay. Might have one for you later.
I've got one.
No.
Okay.
Ms. Rapley, Commissioner McMahon, I've got one question for you on legal submissions. You made the point about not kicking the can down the road, and time to act is now to protect the rail network and avoid constraints on the railway corridor. And I've recorded that as the reason for acting now. What I wondered was, in terms of the reverse sensitivity issue, to what extent does the KiwiRail designation preclude any constraints on the railway network occurring from the introduction of sensitive activities? The designation itself is a fairly powerful technique and tool. We've told that it varies in width throughout the district, from 20 metres right through to 250 metres, and that it has no conditions on it in terms of the operative plan. So why, from a legal perspective, why isn't that the panacea for avoiding constraint on the railway network?
Thank you, sir, for that question. And what we see often in a reverse sensitivity context is it is in future planning processes, for example, where KiwiRail may go to, alter its designation to, include, provide for additional infrastructure or the like, that you often see reverse sensitivity concerns playing out, because you then might have, submitters opposing that change and looking to, impose additional constraints on the rail network. I guess the other point from my submission, sir, is really, yes, whilst the designation is, operationally beneficial for KiwiRail in terms of enabling it to operate, 24/7, it's important that it can continue to do so in order to provide for its operations nationally, and also to have that resilience point. And so it's important that there aren't, additional land uses establishing near the rail corridor without appropriate controls and complaining about that, which can then have that impact of, as I explained, through, future planning processes or the like constraints being imposed on the rail network. So I don't in my submission see the designation and its enabling nature being the panacea effectively for the reverse sensitivity effects.
Okay. Interesting enough, that time for those future changes to the designation is right now. Kiwi Rail have rolled over their operative plan designation, I think without modification and without any new conditions. Those hearings will be heard next month. And I don't believe there's been any submissions opposing the designation, but I'm happy to stand corrected on that. But let's just assume that that is the case for the time being. That's certainly going. If that's the case, then the roller of that designation is largely a formality, and in fact, it's probably debatable whether the council has to actually issue a recommendation on it if there's no under the clause 9 or whatever it is under the first schedule. If there's no modification or no designations, the designation rollover is confirmed. So that's giving KiwiRail a complete certainty on the continued 24/7 operation of their activity within the rail corridor. So I'm just struggling now to understand your answer in light of that.
So effectively, yes, that is, and Ms. Grinton Hancock will be able to talk to that from the KiwiRail designation perspective. But really what these controls are aimed at doing, Sir, is really making sure that land uses which come to the noise and vibration near the rail corridor have appropriate protection by way of acoustic insulation to ensure that they are then not, being aggravated and annoyed by the noise effects, which then in future planning processes or the like can result in other parties seeking, constraints on the rail network. But it's equally as well just, complaints from landowners, which can grow over time and has the potential for, people then to seek to constrain the rail corridor operations in terms of speed or, hours of operation or the like, which would have a compounding and significant effect.
That's a different answer to what you had in your legal submissions. Your legal submissions focused on the continued operation as opposed to the welfare of the receptors who are coming into the tent.
Yeah, it's certainly both from KiwiRail's perspective, and Dr. Charles' evidence talks there as well. It's absolutely the reverse sensitivity effects, and from a legal perspective, I guess our submissions focused on that aspect, given the foundation that reverse sensitivity effects have in case law and the like, but it's absolutely both. The controls are also very important to protect the well-being of the community who live near the rail corridor, and Dr. Charles can speak to that in further detail.
What would be the remedy? I mean, hypothetically speaking, in the event that there is no further inclusion of rules associated with the overlay that's being proposed, what sort of remedies can operators under the RMA rely on to deal with reverse sensitivity?
I think without those, appropriate controls, there isn't really. Because what those controls seek to do is make sure that people, have a healthy living environment, and also ensure that they're not being, becoming highly annoyed by those reverse, those effects, and therefore complaining and, potentially imposing constraints on KiwiRail's operations. So they're a fundamental control from my perspective in terms of ensuring that KiwiRail does have appropriate protection from reverse sensitivity effects. And it would be my submission if they didn't have those controls that it does leave them quite vulnerable from that perspective.
Okay, we might take some of those matters up with your witnesses, including Dr. Childs, but one of the things I did note down from your legal subs was there were two components to the reverse sensitivity. You said firstly that the noise levels that have been predicted warrant control, and that's Dr. Childs' position. That's basically what you've said. What you really haven't commented on is the frequency of exposure to those noise levels, and that's the information that Ms. Grinlington Hancock speaks to. So, would you agree from a legal perspective that both of those elements need to be present for a significant reverse sensitivity issue to arise?
I would, yes, and that's definitely KiwiRail's approach in terms of how these controls are being applied around the country. It absolutely is where there is, noise levels, but also a degree of frequency. Although I would say, and Ms. Grinlington Hancock can speak to this in more detail, I think we do have to look at that both in terms of current volumes, but also future, because it is really important. As Sheila explained, things can change fairly quickly. And if we're not actually proactively planning and thinking about the future, we do run the risk, which actually has happened in other districts, of there not being controls and things change. And then you do have communities being exposed to adverse health effects. Yeah. So absolutely. And Dr. Charles and Ms. Hancock can speak to that.
Sorry to prolong this questioning. Just one final one from a legal perspective. You've taken issue with the officer's suggestion that now's not the time to act, and if there is a need, it might be in the future at some further review. How I can phrase this. Is that a bit of a double-edged thing? Because you and I both know that there's a large amount of reform going on at the moment. Could it be suggested that it's premature to act until the two elements are present? One's the frequency of exposure, but also more certainty about the nature of where the reform's going to land and what the requirements are on councils, such as the combined Wairarapa councils, for using another iteration of a district plan, because, and this is the first review of the combined plan, so it's a combined plan. They made a decision some 3 to 4 years ago to push ahead with the review, which was a brave decision for them to make, given that several other councils around the Motu, including Nelson City, etc., decided not to do that. And on the basis of what was happening with the NBEA at the time, we know what's happened there. So I'm just wondering aloud, really, whether it is appropriate to act now, given firstly what we know about the frequency of services and it being on the lower side in a national sense, and what we don't know about RMA form, and whether there will actually be a need for another district plan as we know it, or whether we might be looking at, to quote Minister Bishop, some sort of national direction on these matters, with one ring to rule them all.
Yeah. So I think it's a really good question, sir, and unpacking those 2 points. I think on the frequency point, even if it is on the lower side of what's comparative nationally, I think absolutely from what KiwiRail sees around the country, it still is of a frequency and level that does justify the controls here and now. And I think secondly, on the RMA reform piece, look, I have absolute sympathy for local authorities around the country at the moment. It's been incredibly challenging, hasn't it, with this sort of on-off nature of reform. And I think everyone is very much just looking for some certainty and an enduring solution going forward. But I think just given that there isn't that clarity, it would be my submission that there isn't a reason, especially given that the council has proceeded with its district plan review here and now, that if it's going to proceed with making recommendations and decisions, that absolutely these controls should be part of that. And I know the expert advisory group has signalled, if that is in fact what gets translated into the legislation, that plans will initially be rolled over as sort of deemed plans under the new regime. So I think we would absolutely want to make sure in my submission that the starting point is that there are appropriate controls in there for QRail. So I don't think that is a reason not to act now, but I certainly understand the challenges that local authorities face in this environment.
Sure, it sounds very familiar to what happened in 1991.
Yeah, it is a bit like deja vu, isn't it, for everyone?
Okay, just finally, would you agree that this issue that we just discussed comes down to the risk of acting or not acting?
Yes, I would.
Thank you.
Yeah.
Thank you.
Yeah, I do have a question, and it revolves around probably liability of action. If an organisation increases their use or their activity by well over 100%, so in this case, KiwiRail is arguing that they're going to increase their use of the line by 100% of passenger services, and have argued that they could possibly increase the line by 500% in freight. Whose onus is it then to provide the remedy for the extra noise that you are creating? Why is the liability on the landowner that abuts your organisation when you're changing your use basically significantly?
So that effectively comes down to what we were talking, I think, about in response to the first question around the designation. So KiwiRail's designation authorises it to, undertake rail activities. It's fairly broad, and it does enable them to increase passenger services over time. The KiwiRail, as a responsible operator under the RMA, is obviously obliged to comply with its obligations therein, including under section 16 to avoid, it has a duty to avoid unreasonable noise. So it absolutely does have that obligation and does take steps, as KiwiRail's witnesses explained, to ensure it does manage those effects as much as possible. But the reality is that there is going to be effects on the adjoining community that KiwiRail can't internalise. And I also don't think we should shy away from the fact that KiwiRail is actually not required to internalise all of its effects. The RMA is not a no-effect statute. And so I think it is entirely appropriate that there is also some controls on adjoining landowners. And I wouldn't say it is entirely shifting the onus onto adjoining landowners. There is, as I've explained, some responsibility on KiwiRail, but this kind of approach where you have managing sensitive activities around infrastructure is very common and very well understood. And I think it is appropriate that there are controls on that use, which is coming to the nuisance. I think that's the other thing, to be aware of, is that those new activities are establishing near a lawfully established rail network, which has been there for a very long time, and can, and in my submission, should be able to operate, in a way that accommodates both its current activities and, future demands.
Is there not a you said gradually increasing services over a period of time. I've lived most of my life in the Wairarapa, and I would say to you that the KiwiRail use has gone the other way over a long period of time, and people have made decisions of where they'll build and so on and so forth. Now that you're changing track, as it were, where does the onus on KiwiRail sit for now? People made decisions based on the fact that the Northern Line was closed, for example. You're arguing that the Northern Lines can be reopened and will be reopened. People will have made life decisions on those, and you're then you're changing the rules of the game, as it were, after decisions have been made. So where does your liability, or where is the strict legal liability about you creating the noise, have some way of mitigating that by noise barriers, or why would the onus be on somebody who has made decisions based on your actions and you are now changing your actions?
I think we have to look at it in my submission from a slightly different perspective, in that we have to look at it in terms of what KiwiRail has planning approval for and what it's lawfully able to generate, and that is So even though there is a rail corridor there, it has a designation, it's entitled to, from a legal and planning perspective, to run its services and generate those effects.
Yeah, nobody's arguing that.
Yeah, and so you're absolutely right that people have made decisions, based on people should be making decisions based on the fact that there's a designation and a rail corridor there where KiwiRail can generate effects. And I think in my submission, it absolutely goes to the point that we should have planning controls around the rail corridor where it exists and where it's KiwiRail's lawfully able to generate effects, for this very reason, that people are making decisions. And so we should be making sure that when they make decisions to locate there, that there are appropriate planning controls, they have acoustic insulation and the like, so that if those rail operations change in the future, that they're absolutely protected. And I think it goes as well in my submission to the need for the vibration alert layer, so that people are also very aware of what they're buying into, that there may be vibration effects there in the future and they can decide accordingly.
Maybe we.
Yep.
Thank you.
I'm not sure that I'm happy.
Thank you, Ms. Rapley. Perhaps we can move on now.
Certainly, I'll call our first witness, who is Ms. Grinlinton Hancock, and she is the team leader for the RMA team at KiwiRail.
Thank you.
Good afternoon. Just checking you can hear me okay?
We can, thank you.
Oh, good. My name is Michelle Grinlinton Hancock and I'm the manager of the RMA team at KiwiRail. Don't propose to read my statement in full, but just give the key highlights. My evidence explains why KiwiRail seeks to ensure the proposed plan includes appropriate provisions to manage urban development around the rail corridor. While KiwiRail supports urban development, good land use provisions are important to manage reverse sensitivity effects and ensure communities near the rail corridor have healthy living environments. The main reason the Council's reporting officer rejects KiwiRail's relief is because of a low number of train movements and the corresponding noise and vibration levels. It's not clear to me how the reporting planner has reached that conclusion, given that my evidence is that this part of the line between Masterton and Wellington is busy. It runs 3 bulk freight trains per day and up to 12 passenger trains per day, depending on the day of the week. While part of the line north of Masterton is currently closed for maintenance, there is 2 bridges that require timber repair work. These currently sit in the ARNIP budget that we're waiting approval on, and then it is intended that those will be repaired. This remains an operational line and could be used at any time to carry bulk freight trains for freight distribution or as an alternative route for the NAMT line into Wellington. The reporting planner has questioned how often this occurs, but the key point from my perspective is that the line provides operational resilience to the wider network, and good planning means there needs to be appropriate provisions in the proposed plan should that occur. As a prime example, Puketoi Bay is a particularly vulnerable section of the NAMT that experiences slips that close the line 3 or 4 times a year. The risk that a major slip occurs is a high probability, high consequence event, as evidenced by the slip that took out the coast road for several months. So the use of the Wairarapa line in a resilience capacity is not an unlikely event. KiwiRail expects that train movements on the Wairarapa line will become busier, particularly on that part of the line between Masterton and Wellington.
There's the Wairarapa line.
Significant capital investment has been made and continues to be made to ensure the delivery of the Greater Wellington Travel Plan. This includes the level crossing program, sleeper replacement, ballast and formation replacement, additional track at Waiangawa to facilitate a 30-wagon freight train. Those trains can be 593 metres long, just for reference. And the purpose for this is to allow for the marshalling of trains at the log siding. The reporting planner is concerned in her summary statement that KiwiRail has not provided actual numbers of future train movements or increases to freight trains to warrant controls. The absence of specific protections should not be a reason to reject the controls, particularly given that current train movements mean that this is already a busy line. In speaking with the freight team just this morning, they've indicated that they are in current discussions with a customer, which will more than likely result in an additional freight train in the next month. Things change rapidly, with very little notice, depending on customer demand. QRail also seek the application of a rail vibration alert layer over 60 metres either side of the rail corridor. This acts to put people on notice that the rail corridor is in proximity to their properties, so they can choose to change their behaviour to mitigate effects. That it only serves an information purpose is not a reason to reject it. It still serves a useful purpose and is a pragmatic approach from QRail's perspective that also has been accepted in other parts of the country. QRail's position is that these rail and noise vibration provisions are reasonable and necessary to protect the rail corridor and those who will live and work near it in the future. They should be included in the proposed plan now rather than reserved for a future district plan review process. Happy to take questions.
Thank you. As I requested of Ms. Rapley, could you please email through your speaking notes?
Yes, I
as
can.
well? Yeah. Just before I hand over to other panel members, just a point of clarification, you actually mentioned that the Wairarapa line is a busy line, particularly the portion between Masterton and Wellington. Are you familiar with the Wairarapa?
Yes, I am.
Yeah.
Reasonably, yeah.
Yeah, so the Wairarapa line is actually only between Masterton and Wellington. So just as a point of clarification for you. And you've also mentioned that the two bridges that are requiring repair on the line north of Masterton, so heading up to Tararua, and that could potentially be an option for resilience should other lines be closed, the North Island main trunk line.
Mm-hmm.
But you mentioned that they are waiting on budget approval for repairs.
Yes.
Because as we need to, as commissioners, work on evidence on tangible, this has actually occurred, and having been in the Wairarapa and been waiting for years and years for budgets to be approved to increase which our passenger service in the first instance, there is no guarantee that a budget will be approved in any time in the immediate future. And I think that just raises a little concern for me, especially we're going to be in for a change of government fairly shortly again, and who knows what will happen then. So I guess local government, sorry, and then also central government. Sorry, local government, yeah.
What do you know?
So local government, but then again, next year there's another central government election. And I guess, do you know when the budget approval is likely to be granted?
So, yeah, a few years ago, QRail was on a year-by-year budget approval, which made life exceedingly difficult to work Plan 2. That has now been changed to a 3-year budget, and so every year we put in a budget, and my understanding is that the budget is to be approved within the next couple of months. We've been told a couple of times that it's waiting, but as far as I'm aware, it's going to be approved in the next 2 or 3 months.
But there's no absolute guarantee that it will be for this particular piece of work.
I don't know, to be fair.
Yeah. So okay. So I take that there's no guarantee. And I just I think I probably speak on behalf of the panel that in all of your evidence you mention that the Wairarapa line is a busy line. I would put it to you that actually living in the Wairarapa, it's not a busy line at all compared to other centres. And I think in someone's evidence, Whangarei was put forward as a precedence. And the Wairarapa line is a small regional connector into our main city, and 3 commuter trains first thing in the morning and a couple of passenger trains in the middle of the day isn't what we living here would term a busy line. So I'm just interested in how you came up with that definition.
In comparison to other parts of the country, it is a busy line. Whangarei, for example, where these provisions have been accepted, has much lower levels of train traffic than the Wairarapa. I guess as well, the other thing that we take into consideration is the Wairarapa might be considered to be less busy than Wellington, for example, except the majority of the trains that operate through into Wellington are not based on diesel engines. They're based on electric, which makes significantly less noise than the diesel engines.
So are you aware of the hybrid trains that are coming to the Wairarapa?
Yes, I am.
Yeah.
One day. So my understanding is those are currently in testing down in the South Island.
So again, that's from a Wairarapa point of view. These trains have been promised, and it's now pushed up for 28, 29, possibly, maybe. The other thing, by increasing the frequency of trains, and we had a very good presentation at one of our councils the other week regarding increasing the services, that needs to be taken into account is actually the train link over the hill from the Hut into Wellington. And so whilst we might increase our train services in the Wairarapa, that may not be possible because of the number of trains in the Wellington region as well. So that's kind of not for this discussion, but that's kind of at the back of our mind a little bit too.
It's an overall network issue and capacity issue. And one of the things, that's why a couple of passing loops have been put in play. So we've put in additional track for those. Because freight trains are slugs, they're long, they're slow, and so the passenger trains always take precedence, and so that's why you take the freight train off so that the passenger trains can run.
Yeah, thank you, I understand that. Okay, I'll open up to questions from the panel. Yep, Craig.
Thank you very much for your presentation. Just a comment around, you've talked about the frequency on the Masterton to Wellington line and the freight that is involved. Are you aware that there isn't a single freight train that originates out of Masterton? It all operates out of the Cardigan district at Wainawa?
Yes, I am.
Yep. So that has no bearing on any of these relief or what you're seeking in the Masterton district?
So this is the combined plan though, so it covers the entire district. So these provisions would cover the entire district, not just Masterton. But also, regardless of the freight trains, the passenger trains are currently led with diesel engines, and it's the diesel engines that make the greatest amount of noise.
So it's the diesel engine, not the length of the car that makes the length of the freight train that makes the noise.
So noises generate. So trains generate noise at 2 points. They generate noise in terms of the wheels on the track, but they also generate noise at the exhaust stack on the engine, which is approximately 4.2 metres above track level.
So is a freight train noisier than a passenger train?
It is in that it's heavier, but there's diesel engine noise regardless.
Answer your question, thank you.
Yeah, thank you. I've got a couple of questions. Could you tell me the last time a freight train went north of Masterton?
No, I can't, I'm sorry, but I can ask.
I got, 5, 10 years, 15 years.
So I asked that question of our local track engineer and he was not able to tell me this morning.
Well, it must be a long time then. Okay. Then you made a comment and said that I think it was Porirua, you said high probability of earthquake or flood or bank collapse. And therefore,
Porirua Bay, yes.
Porirua Bay.
Yeah.
My question then is, if that is such a challenge and such a risk, why has there been no maintenance on the line north of Masterton as you use as your argument?
I would have to ask the track engineers.
Yes, you see the problem here. You're arguing one thing but done nothing about it and expect us to then to put into place certain conditions that you've done nothing about. Then my third, sorry.
I was going to say, unfortunately, KiwiRail is dealing with 30 years of deferred maintenance and budgets have to be put to put to what is most concerning at the time.
I do not disagree with that at all, but you use a particular argument to justify an outcome that you're seeking from us, and you have not displayed anything to mitigate that. Therefore, I've got to question the rationale of your argument. And the third one I've got is the issue of the rail corridor and the security of the rail corridor. A couple of hearings ago, we dealt with issues. What was the
height
restrictions and what was that? There was zoning, wasn't it? Was it in the zoning hearings?
Yeah.
So in the zoning hearings, and you weren't involved, but if I find it really interesting that in the same sort of arguments you're using in this hearing are the same arguments you used in the last, or the KiwiRail used in the last hearing, that said, the onus is on the landowner. You take no responsibility for the security or the issues of your road corridor and say, we've got a designation, we can do anything. And the problem is actually our neighbours, not ours. And it seems to be the same argument here. And I just wonder, at what stage does KiwiRail accept that whilst you have the designation, you also have a duty of care to people who not only live beside your rail corridor, but anyone who may well transit across or walk past, and the security and health and safety of people. So I come back to the original question that I asked about, where is the onus on KiwiRail to perhaps put sound barriers up, which may well do something along the lines of actually providing security for the rail corridor. And I'm only talking urban environment here. I'm not talking rural, because really the sheep don't matter. But, when we look at the railway line in the Wairarapa, where it goes close to urban houses, it's not a huge distance, in terms of massive distance. And yet the cost and the rules we're placing on the few people that live along that corridor is a big burden.
So KiwiRail does do things like make sure that the wagons don't have flats, because that significantly increases noise. So all of the wagons go through a maintenance check program to make sure that they don't have that. We do go through regularly with the tamper and make sure that the lines are the correct gauge apart, and to make sure that if there's any soft spots or anything else in the track, because those things all add to vibration, they also add to noise. So we do those things in order to ensure that we are minimising our effects as we can. With regard to fencing, look, if I could get the government to pay for fencing of the corridor, because that would get rid of a whole lot of issues. Unfortunately, the government doesn't seem to think that fencing the rail corridor is a primary function of KiwiRail, but
But here's the crux to that though. Here's the crux there. You're saying it's not a priority for you, so let's put the onus on the neighbours.
I'm not saying it's not a priority for us. Unfortunately, we are constrained by government funding, and if I could get the government to fund fencing of the corridor, I'd do it in a heartbeat, but that's what I work with.
Okay, so just the fact that you can't get funding, does that mean that is justification to put the onus onto your neighbour?
No, but we do our best with what we've got, to work with our neighbours and to run a rail service.
Yeah, I think that's probably, yeah. You understand what I'm saying here?
I do, yes.
Thank you.
Yeah, Commissioner McMahon here, Mr. Grinlinton, Hancock. Two questions from me. Sorry.
Sorry. Yeah.
Sorry.
Sorry.
The first one's just in relation to the questioning from Councillor Plummer about the most appropriate solution. We established with your council that the issue is one of acting, the risk of acting or not acting. Given what you've just heard in terms of no freight usage between Wainawa and Masterton, and given that Masterton is the only authority of the three that is actually a Tier 3 authority and to which the MPSUD applies, and given that because of that, Masterton, unlike any of the other districts currently, is slated for some medium density development, it seems to me that the risk of acting needs to be informed by what's the chances of the pollution from noise increasing in the planning period of this district plan, and that comes down to the likelihood or unlikelihood of further freight usage north of Wainawa. But secondly, in terms of costs at least, it'll be those areas north of Wainawa, around Masterton, that will actually bear the cost, because that's where the greatest infill will occur. That's where the new greenfield developments will occur. So from a planning and Section 32 analysis, it seems that the risk area, the Masterton area, is one where the risk of reverse sensitivity is lower, but the costs of actually dealing with reverse sensitivity are higher, and that just seems to be inequitable. I wondered if you wouldn't mind commenting on that.
So I think we need to step away from straight up freight trains. As mentioned before, the passenger trains are pulled by diesel locos, which are noisy in themselves. So it's not just about freight, it's also about the passenger services as well, which Greater Wellington has indicated that they are going to increase. And so therefore, if there's increased services, then those would impact on those people in the additional housing in Masterton. Greater Wellington has put in a lot of money so that the frequency of services can be increased. So I can only work with the numbers that I'm given.
Just on that, two things seem to come up. At the moment, we've got 10 to 12 passenger trains a day.
Mm-hmm.
There may be changes, there may not be changes, and you've already indicated that because they're lighter trains, even though they're still pulled by a diesel, the noise propagation is less than a freight train. And you've also indicated in an answers to councillor sitting next to me that the hybrid trains would be less noisy also. So in terms of the foreseeable future, the 5 to 10 year planning period, it seems that the risk of reverse sensitivity issues arising in that part of the track between Wainawa and Masterton are low, but yet the costs of dealing with reverse sensitivity in terms of the costs on the receptor are potentially high, and that just seems to be an imbalance.
Okay. I guess that's your take on it. I don't necessarily agree, but
what part do you not agree with? Do you agree with the costs? Do you disagree with the costs being greater in that part of the district than other parts?
My understanding is the costs are about 1% of a build. So,
well, again, that's not the evidence. The evidence was around 3%,
Okay.
Your own evidence, and I had some questions about that. But what about the total? I mean, that's possibly across the build of a new development, but presumably the cost of mechanical ventilation as part of a alteration or addition would be a greater percentage than its cost as a percentage for a new build.
I'm not sure. You'd need to talk to Dr. Charles about that.
Yeah, but surely it makes sense if you've got a brand new development and you've got cost of mechanical ventilation on that, the percentage will be less if you're dealing with one new habitable room that you're adding and have to mechanically ventilate it. As a straight proportion, common sense, surely.
Potentially so, yes.
Yes. Okay. Okay. Well, I'm trying to relate this back to the Section 32 test that this panel has to grapple with, and I'm just seeing some potential misalignments that I was hoping you could help with. Okay. That's fine.
Any other questions?
I just have a little one. So, kia ora, Ms. Grimlinton. My question, I just want to kind of go back a bit. You talked about that Kiwi Rail is behind 30 years on their maintenance. Is that the maintenance for the whole of the rail system in the country, or is that just where?
No, unfortunately, KeyRail has been in managed decline for a period of approximately 30 years, so that is maintenance across the entire country that we are in catch-up mode on. The government has recently provided a significant cash injection into the Wairarapa and Wellington Metro system, and so we are busily spending that money to deal with those maintenance issues.
So the priority then for the Wairarapa link, say, where would we be in the priority?
I work across the Wellington Metro program, and the Wairarapa has the same level of importance as the rest of the Wellington Metro. Like, we're spending money equally on that. From what I've observed, yes.
Thank you.
Signals up great. Thank you. No other questions? Dr. Childs, did you have anything you would like to add? And if you do have any speaking notes, if you would be able to email those through as well, that would be fabulous.
So I don't have speaking notes. So good afternoon, panel. I won't get into my evidence too much. As you may have seen, there isn't a large degree of technical disagreement between myself and Mr. Ivan. There's a minor point on distances, which I will just briefly expand my position on that. I'm not the questions on train numbers sit with KeyRail, not myself. In terms of the noise and vibration effects, when assessing rail, the characteristics of a railway line versus a road, I work a lot with state highways, are very different in terms of the way traffic and noise changes over time. So for a road, it tends to be small incremental changes. For a railway, the 100%, 500% change in volume isn't unusual. That's the normal operation of railways in New Zealand, and I think if you ask Michelle Grillington Hancock, she can point you to examples where a contract's suddenly sort of been won by Kiwi Rail and some line that had virtually nothing on it has suddenly got a fairly regular service. So the operation of rail in New Zealand, a characteristic of it is that as commercial contracts come and go, the freight in particular volumes do change by large percentages. So when I'm assessing effects from an established rail corridor, I've got one eye to any activity that's happening now, but I'm talking to Kiwi Rail about, well, what's the importance of this line? What's the likelihood of change? When I've asked those questions for the Wairarapa area, there's I've been told this is a strategic route. It provides an alternative, and that freight service throughout the area should be the basis for my assessment. So in terms of the details of the numbers, I won't go there, but just in terms of how I approach it, to accurately assess noise and vibration effects of rail, you do have to take into account the changing nature in relatively short timeframes. The other thing that goes hand in hand with that, which I really need to stress, is that the numbers for the cost of treatment to houses, I'm not sure where the 3% came from, but the raw data that Christchurch City Council did a big review of how much it cost, and it was sort of 1 or 2%. It's for a new build, it's a relatively low percentage. So there's a real efficiency while you've got builders there, you can incorporate the necessary measures. You only get that opportunity to do it for that in that efficient manner when you're building a new house. So if you defer the decision on implementing these rules for 10 years, there's a whole bunch of houses where you've lost that opportunity and you'll never get it back again. So this is kind of a forward-looking land use planning where you've got two incompatible activities. You've got a rail corridor that's there, it's established, and it's known that it could increase operations at any time. And then you've got something coming to that, and you've got this one hit to address the noise and vibration effects efficiently. So that's some of the logic on that. So I'll just turn to address this question between Mr. Arden and myself about the differing distances on how far control should go. And if I can refer the panel to this, the Appendix 1 to my evidence, I've got a comprehensive advice report that I provided to Kiwi Rail for these issues nationally. And within that report, I set out the World Health Organization, the Europeans, they work on daily average levels, and they've got night weightings or whatever it is. And we use those in New Zealand for roads and airports, where we look at these 24-hour averages. And when you've got a lot of events, those 24-hour averages, it'll be the overall exposure or the dose, can be used to represent the noise effects. So if you've got lots of aircraft movements through the day, you can take an average and it tells you something about the adverse effects that will occur. And as I've set out in the report, and particularly if you want to look afterwards in section 2 and then again in section 4, there's a problem for rail in New Zealand where you've got, compared to the aircraft, you've got relatively infrequent events. So if you take a 24-hour average, that will give you an under representation of the impact of the single train pass by. So a single train pass by is relatively loud, as I'm sure everyone in the room's experienced that sometimes. If you're standing close to a rail, there's no missing the fact a train's going by. It's far more than a heavy vehicle on a road or so forth. So if you average that single train over 24 hours, you're not addressing the effects of that train. And so there's got to be but if you take just the maximum level, the single highest level as the train goes past, then you're over-representing the effects. And as I've set out in that appendix, and say you go back and have a look at it, there's not a perfect answer. The international literature, the research around the world doesn't give us the answer. There isn't a single figure where we can combine the train frequency and the level and say, well, this is the way in which the effects are far more nuanced and complex than that. So what Kiwi Rail's done, and it was originally based on advice from Mr. Arden's company, is it's gone for a 1 hour average as being a pragmatic control that doesn't average out the noise effects over the day, and it doesn't sort of take the worst case seconds as the train goes past. And that's the basis on which these controls have been derived. So you're trying to control that 1 hour average. And I think what Mr. Arden was pointing out, that you get this slightly erroneous situation where when you get beyond a certain point, you're assuming the same level. So a line with twice as many trains, you actually need the same level of control because you're still trying to control that worst case hour. So if you read through the discussion in that appendix on sound levels, that explains on a factual basis how in my opinion, the adverse effects that warrant control do extend out to 100 metres. In fact, sometimes extend out more to 100 metres. And then before I invite any questions, the only other thing I'd like to address is a question that's come up a few times around, well, why doesn't Kiwi Rail put up noise barriers everywhere? And there might be administrative, budgetary reasons why that doesn't happen. But there's also a technical matter at play, which is that where I have been involved in putting up noise barriers by railways, and there's an example in Mount Maunganui that comes to mind. They're 5 meters high. So for a diesel train, which is about 4 meters high, to get effective noise screening, the noise barrier is 5 meters high. And if you look at that example in Mount Maunganui, that's a few hundred meters, you end up with an enormous concrete wall down the side of the rail corridor. If you've then got a house that's elevated above the line, quite often the rail's in a slight valley or a cutting, you'd have to be even higher. So technically, it's simply not practical to build a high enough or long enough noise barrier to mitigate the rail noise sort of with the barrier in the rail corridor. So there are some places where there's some works in the example I'm talking about in Tauranga where the barrier might be effective, but on a district-wide or region-wide or nation-wide basis, it's not the solution. And my urban design friends would soon have something to say if I proposed 5 meter high concrete walls down the length of the rail corridor. It's just not a practicable option from a technical perspective, regardless of any other constraints. That was all the points I wanted to bring to your attention. I'm more than happy to answer any questions.
Thank you. I'm sure there will be some. Thank you, Dr. Childs. Any questions from the panel?
Yeah. Afternoon, Dr. Childs. Commissioner McMahon here. We had a long discussion this morning with the officers where we spent about an hour and a quarter on this entire issue with the planning officer and Mr. Arden, in relation to noise matters. And a lot of the matters and questions that were put to you have come out of that discussion. One of the matters that I was interested in getting an understanding of was how the table in your evidence, which equates setbacks to predicted noise levels, relates to this district. I understand from Mr. Arden that his own company was involved in putting together that information initially, and that's
correct. Sorry, you carry on.
Yeah, just a little bit of context. Obviously, that table's been used in your evidence, and it's been used in the Taylor Planning Section 32 at a national level, and there's obviously no dispute about the accuracy of the information. We accept it for what it is. What we're trying to understand though is what the basis for forming that table was and how that table applies to the Wairarapa district. We understand it's based on 2 freight trains in a 1 hour period, and which is probably an overestimation of on an average at least, of the situation that prevails in the Wairarapa. And Mr. Arden suggested that if you went down to 1 freight train per hour on average, you're probably looking at a 3 dB reduction in relation to those figures. So at 100 metres, instead of 56 dB, probably 53. Do you have any comment on that at all?
So I was trying to preempt the question, but didn't quite get there. So this comes down to this this averaging over 24 hours as opposed to taking the worst case second as opposed to taking the worst case hour. So as you read from the thing, so the numbers which came from Ofsted, they equate to roughly 2 freight train movements in an hour. Yes. And there's been, I mean, the basis for that was quite old. There's been a whole load of more recent measurements on the various newer locomotive types, and the numbers have held true, sort of, yes, within reason. But so assuming 2 freight train movements in an hour is an approximation. So you're trying to. There's not a precise dose response relationship where you can say, okay, this house has got to achieve this many decibels not to get an adverse effect with 3 trains spaced out through the night as opposed to 2 trains at midnight and then 1 train at 5 a.m. We don't have that level of sophistication. So all of the evidence we do have, and there's a big one of evidence that I've referenced there saying that there are definitely adverse health effects. It is indicating that at this level, if we only had 2 freight train movements in a day and we applied that level, we'd probably be overcooking it. And if we had 6 or something, we'd probably be about right. So on the basis that the Wairarapa line can take 10 freight train movements a day within the life of this plan, including the northern section, they take reasonable volumes of freight trains, 4-6 freight train movements a day, then that assumption of 2 trains in an hour is, in my opinion, appropriate. And I think the point of discussion is that there isn't a body of evidence that lets us sort of pin down the relationship any tighter.
Yes, that's a very useful answer, Dr. Charles. Thank you for that. What that suggests to the panel is that based on current train numbers, 3 freight and 10 to 12 passenger, and acknowledging Michelle's point about that could change in the future in terms of what might happen to the Northern Line, whether there are additional freight customers, that sort of thing. But at the moment, it's 3 freight and 10 to 12, which probably does only equate to the 1 to 2 per hour on average. Aren't we dealing then with a potential impact that then needs to be considered in terms of the likelihood of that occurring, and then dealing with the risk management associated with that likelihood? Aren't they the 3 factors that we have to consider? That it's a potential, it's not a current impact, it's a potential impact. We need to look at the likelihood and then the risk associated with that likelihood. I think Council confirmed that we are dealing with a risk of acting versus not acting scenario here.
So to unpick that, so as I've said at the outset, I'm not going to get drawn into rail for movement forecasting discussions. That's not my expertise. Those questions need to go back to Michelle Brennan Hancock. In paragraph 5.6 of my appendix, where I talk about underneath that table, I say, well, if you've got, say, 6 freight train movements a day, or you've got some at night, then the numbers are probably applicable. And I explain in there that this isn't that there's not a hard science. There's an element of judgment there. So for these districts, you've got sufficient freight passenger trains during the day, and you've got the potential for freight movements coming through at night. So on that basis, I consider that the controls are warranted now on the section south. And I'll note in my report where I talk about passenger trains, that was the original Marshall Day work was based on the EMUs on the not the diesel pool. So the comparison won't be exact there. And in terms of in other areas around the country, when I've gone to KiwiRail, they've said, look, there's no realistic prospect of more than a movement a day or something here. I'll say, well, from a noise effects perspective, you can't justify the controls. And, the most recent example there is the Hokitika line, where KiwiRail turned around and said, well, okay, we'll just put an advisory layer on there. And there's a number of branch lines around the country where that's occurred. When I asked the question here, it's like, no, this is an important part of the overall network that's designed to carry freight and could be carrying freight within the life of the plan. So that, in terms of those statements, that goes back to KiwiRail, but that's the basis for my noise assessment and advice to KiwiRail.
Okay, thank you for that.
Yeah, I've got one. Thank you very much. You said that your train movements are based on a 24-hour period. Most of our urban trains are within a 12 or 13-hour period during the day, with 1 freight train at night 2 freight trains during the day and the other 12 of 13 hours are urban trains. So are your figures a little bit misconstrued in the sense that they're averaged out over a 24-hour period, and or is there a contingency in there allowed for?
So they're not averaged over 24 hours. If they were, I think that would be misleading in terms of the effects, and that's one of the reasons why I'm saying don't average them. It would be lovely if it was a road and there are thousands of vehicles, we can just take an average and it's a good representation, but we can't, and so that's why we've had to use this different approach. So as you were saying before, it's things like the freight movements at night. For me, that's a kind of a key threshold that you cross in terms of potential effects. And then how many times can you be woken up before it's a problem? And in terms of the conversation, there was a lot of conversation around reverse sensitivity and risks and so forth. But for me, it's a straight out human health thing. There's an opportunity for a low cost when you're building a house to avoid an adverse effect on health. And from a technical point of view, it's frustrating when that's not taken, because you're avoiding sort of harm to people. So yeah.
Can I just have a follow-up question to that? Building a new house, I understand. What about an additional of a habitable room that's already there? I mean, there'll be an additional cost that will be proportionally greater for the habitable room than it will be if it was spread across an entire house. But also, it will only be the new habitable room that is subject to the attenuation. Existing habitable rooms will still be exposed to the noise. How do you rationalise that?
So for roads and rail, there's a nationwide health impact from the operation of the existing networks, and that's the same in Europe and around the world. There's an existing adverse effect, and the point about these controls is to stop that getting bigger. Over time, it needs to reduce, and this is there were sort of questions before about what KiwiRail does to avoid these issues arising. This is one of the steps that it can practically take to avoid compounding an existing situation. In terms of the differential costs, so I don't have data on the differential cost for an alteration. I think it's important to bear in mind we're not talking about repairs and maintenance. So repairs and maintenance, no one's saying that these
we understand that. It's just a new habitable room where you might
an extension.
You might convert the garage to a dwelling, or you might put in a sleep out, or you might just add another wing on with another bedroom. Yes.
So I don't have the percentages. In terms of the key costs when you're putting in a ventilation system, there's the hardware cost, but it's opening up the ceiling to put the thing in, and if you're retrofitting, to run your duct roots and make good the plaster work. When you're refurbishing your garage, you're relining it. Everything's exposed. You've got everything available, so the incremental cost is still going to be relatively low to do the works at that stage, because it's the project management, the builder's work that really affects the cost of something like a ventilation system. So there might be some economies of scale that a big fan that will serve 4 rooms is going to be relatively cheaper than a smaller fan that will serve 1 room. But those key costs around the sort of builder's work and you should still get those same efficiencies when you're converting your garage, or if you've got a commercial building that you're carving up into apartments, it should still be a similar level of effort.
Okay, that was the first part of the question. The second part was that attenuation is only going to apply to the new habitable room. There's a sensitive activity that's been existing there that has habitable rooms. Won't benefit from that. And that was my response, that we've got an existing health problem. So all of those, so there's an existing health problem, but from a technical point of view, that's not a reason to say, well, we're not going to try and do better when we can. So you don't, if you've got a new habitable room, it's got to meet all of the building code. It's got to meet the whatever thermal air type regs there are for the building code for that habitable room. You don't have to
rebuild the rest of the house. So you're making the new space fit for purpose. The rest of the rooms in that house are what the rest of the rooms in that house are, as are any other houses. But you're trying to avoid you're taking opportunities where you can efficiently avoid an issue sort of increasing over time.
Certainly, the benefits are not lost on the panel. We understand the benefits. I guess if we do have a question, it's about the costs to achieve those benefits, particularly in terms of alterations and additions to habitable rooms as opposed to new builds. And also in relation to that part of the track where infill and development is going to be at the greatest, it currently doesn't have any freight component.
I think one of the advantages of having the controls for that northern part is where you've got larger lot sizes and there's options to locate away from the effect. That's the free solution. If you've got the land available and you can locate further away, that's a good outcome. If there's other costs involved of servicing or whatever, and you've got to build close to the track, then you're weighing up one cost against another, and there is a cost to get healthy living conditions next to a major noise source, and so that's it's making sure that when people are developing those sites that they've got that there as a factor that they're including in the design.
Thank you.
Thank you, Dr. Charles. Commissioner Cherry Campbell here. I just have another question for you, Ms. Rapley. In your evidence on submission, on 4.2 in your legal submission, and then 4.3, you state that KiwiRail has taken a pragmatic approach and seeks the inclusion of a vibration alert layer, and then that could apply to properties within 60 metres. And at 4.3, you state a vibration alert layer is an information layer to signal to property owners that higher levels of vibration may be experienced in the area due to its proximity to the rail corridor. There are no rules or other provisions associated with the vibration alert layer. Reading that, I take from that if we incorporated, if the panel was of a mind to incorporate a vibration layer as an information layer, that KiwiRail would be comfortable with that approach. Is that correct?
That's correct. Yes. Yep. And Ms. Oh, can you hear me?
Yes, we can.
Yes, that's absolutely correct. And Ms. Hevelthwaite's evidence, I think, sets out the amendments that KiwiRail seeks, which effectively is to have some drafting in the plan that explains that approach, that it is an information tool, there's no provisions, but it would sit in the GIS mapping layer of the plan, so that, if a landowner were going to look at their site, it would pop up that there was the vibration alert layer there.
Thank you.
Yeah.
Okay.
Sorry. Yes. I think now we have the last.
Can I just ask a question? It's only just my own personal curiosity. With these sound level readings that were done, what speed was the train going at in those readings?
The numbers have come from a range of readings. Typically, the freight train will be going at 80 kilometres an hour. Yeah. If that sort of question, sorry, can I? I've got a routine medical appointment, so I'd like to be excused now if I can, but can I also ask, there's been some correspondence with NZTA. My understanding is, am I correct that the NZTA planner is no longer speaking? So am I clear for NZTA questions as well?
Yes, so the NZTA, the reporting officer, has accepted NZTA's request. So yeah.
I don't have anything to talk to the panel about, but I was just making sure I'm free to.
Yeah, absolutely. Well, thank you so much for your time this afternoon. Really appreciate it.
Thank you very much.
Thank you. So, Ms. Hevelthwaite.
Yes, good afternoon, panel. Excuse me, I'll adjust the lighting. I realise you probably can't see me very well. Hopefully that's better. My name's Kath Hevelthwaite. I'm a planning consultant and I'm assisting KiwiRail today with regard to the noise provisions. I don't have any written speaking notes, but I do just intend to cover off both the highlights, if you wish, from my primary statement, and there was just a couple of other points that I thought might be
helpful to the panel to add with regards to the discussions proceeding. So in that regard, my focus is primarily on the provisions which we are looking at in terms of alterations and to make sure that they are clear and understood. And just for completeness, I know this hearing also addresses lighting and signage, and Kiwira did make a number of submissions on both of those topics, and you'll see my evidence that I am quite comfortable with the recommendations of the officers. In that regard, I'd just like to point out primarily just a reminder to the panel, because I'm quite sure you're well familiar with this, the Wellington Regional Policy Statement, particularly Policy 8, which you'll find repeated on page 3 of my evidence. That's paragraph 4 and Roman numeral 4. And so it might be helpful to just emphasise the second line of that paragraph, which says, and I quote, district and regional plans shall include policies and rules that protect regionally significant infrastructure from incompatible new subdivision, use and development occurring under, over or adjacent to the infrastructure. And Roman numeral paragraph 5, I've also got there, that's a policy 8 explanation, which is just about further down page 3. And you'll see there I've highlighted in bold a number of parts of the explanation, which I think are quite helpful. And particularly the third paragraph down, the paragraph that's immediately above Roman numeral 6. You'll see that the second line says that the land uses are not to be prevented. It doesn't mean that all land uses are to be prevented. And I think that's something which has stood out to me in today's discussions, is that the focus of the provisions which I've included in my evidence will apply to new activities or altered activities. And you'll also see in my evidence further along that I've had a look at potential land development scenarios and availability. It is a high-level assessment only. I haven't been around to all of the various townships. I've looked on aerial photographs. I've been quite clear about the basis of that. And a large number of properties are already well developed. There will be no impact of this on those properties unless they change their activities. So I thought that was probably a useful start point, because there's been lots of quite interesting discussion about effects and how this will impact the residents of your communities, and obviously goes beyond residents as well. We're talking schools and childcare and other activities. But that would be just for me, that was context from where we're looking. The other items in my evidence really are focused on explaining the changes to the provisions. I'm quite mindful that the reporting planner has proposed largely not to accept those provisions. And I'm wondering, is it helpful for the panel if I walk through those in regards to the changes I proposed and why, so that is clear as to how they fit in and what the start point for those was. Or if you've had a chance to perhaps read the provisions and maybe they were part of your discussion with the council staff this morning.
I'm happy for you to briefly step us through those.
Okay.
Yeah.
If you can just point out which paragraph, etc., that you're on.
Yes, certainly.
Thank
So
you.
if you're able to turn to page 14, that's my attachment A. So the red text is changes are proposed, and the black text is the reporting officer's 42A recommendations with the changes accepted. So where the council planner is comfortable, I have adopted their position primarily for ease of reference.
Thank you.
See there, the first heading, we've got the 2 overlays, which I'm proposing are added to the maps. One of those is, as Ms. Rapley has described, as the noise the vibration alert overlay, which is a mapped layer, and the second one of those is the noise overlay, which is again a mapped layer. And the note in my evidence here is to indicate that they are not a written form of control. They are actually proposed to be on the GIS maps. So when plan users open them up, they're quite readily visible. The second point there is definitions, and the reporting officer has accepted some changes there, particularly in point C around hospitals, and also relative to Kiwira submission, there are a number of things Kiwira submitted on which I felt weren't necessary. So there is a difference between Kiwira's submission and what I have recommended going forward. Now, the definition is quite a critical change, although it appears fairly innocuous, is because the definition provides a framework, if you like, which then feeds through to the noise rule R16 on page 15, and probably more importantly, the noise standard S4, which is covered in table 16. And if I just might quickly go to table 16, page 16 and table S4. Now, near the bottom of page 16, you'll see a table which also continues over onto page 17. So in that table, there are 3 columns. There's the one on the left, which just says it's a noise control for rail boundary. There's one in the middle titled activity, and then there's one on the right, which is the noise levels listed. So whilst the definition is fairly high level, it has general activities, it talks about healthcare activities in hospitals and congregations. Table S4 then digs down into the detail, if you like, of the specific rooms and types of activities which occur within the higher level definition. So if you look here, we've got a particular noise level for bedrooms. We've got one for lecture rooms, and obviously you can go down the list there. And whilst healthcare and hospital facilities appear in the definition, the actual levels required for the specific activities which are highly sensitive are much more confined to those things listed in S4. So if we take the healthcare example, we've got there that it is overnight medical care, wards, clinics, consulting rooms, theatres and nursing stations. So whilst a healthcare facility might also include offices and perhaps reception areas and other non-clinical space, the noise limits and the provisions proposed only apply to the very specific things listed in S4. And you'll also note that the noise limits in the right-hand column are variable between 35 and 40 decibels based on Dr. Child's advice as to how sensitive those activities are for noise. So that's the importance of how the provisions fit together, and by perhaps not adopting definition change or the other resulting changes to the particular standards, it can lead to a less than cohesive approach, because the overall approach here is to target the most sensitive activities. In the table on S4 on page 16 and rolling into 17 aims at getting just those activities which are most vulnerable. I thought that's probably the key message, but I will just briefly skim through the rest of it so it's clear. You'll see, just returning now to page 14, that Ms. Rapley has already described to you about the vibration alert overlay. I might just digress there. I noticed the reporting planner in her summary statement felt that wasn't terribly useful, and I did detect some flavour of that from the questioning earlier. In my experience, the value in the overlay, although it has no noise actual provisions and requirements, is often felt through a slightly convoluted chain of events, which usually starts with a homeowner looking to purchase a property, and particularly when it's a new property, being alert through a limb that there is a potential limitation, that there is a potential possibility of different types of effects and they might be used to on a site. For example, the vibration. Another example could be a potential flood hazard. And then the potential purchaser asking questions of either the current owner, or perhaps it's a new building, so it may be a developer, as to what the existing building has in the way of protection against that potential issue. So it is a bit of a step-through process, but that is where the value can lie with having an overlay with no provisions attached to it, i.e. you don't have to build something now, but it does alert future occupants and residents to the fact that there is the risk of something which they might not otherwise have expected. Just return now to page 14, so that covers off the explanatory text for the overlay. I have proposed an additional policy at policy 9. I'm not convinced the policy structure is quite as robust as it could be. And then obviously rule 16, which is on page 15 of my evidence, sets out the specific rule which would apply for noise. On page 16, we've obviously got the S4 table, which sets out in a lot of detail the actual provisions which apply. It also sets out ventilation requirements, and if you go to, where am I up to? And the requirement for a design report. So there are, in S4, there are a number of compliance pathways. So this provides applicants, and particularly there, I'm looking at the table, there is numerals 1, and under that there is A, B, and C. So there are effectively 3 compliance options for future builders of homes, for example. So the first option there is that the tables in S4, the values in S4, the building is built in accordance with that and it meets that. So that's the first option, that's option A. The second option is where a building is 50 metres at least from the rail network, and there is something there which blocks the line of sight from the windows, and you heard Dr. Charles before discussing the noise source and location and height of rail locomotives. So that covers off option B. If you're far enough away and there's something in the way, then that becomes a permitted activity, no further design required, nothing else needs to happen. And the other option is C. This is a design schedule which has specific things which architects understand and draftspeople much better than I do, that says if you build your building in this manner, it will comply with the rule. The reason being that the building materials and design provide sufficient acoustic attenuation to achieve the internal noise levels. So I just thought I'd point that out, that there is a sort of a 3-pronged compliance pathway there available for plan users. Obviously, the first one of those is design something specific. The second one, ensure there's suitable setback and blockage. And the third one is build in accordance with a specified methodology. I think that's just largely the key points here. The rest of it is quite detailed. I'm happy to answer questions on it, but it may be more useful if perhaps you might have some questions for me.
Thank you very much. Looking to the panel.
I've just got one question. In your mitigation under ventilation, you mention an HVAC system. That's a trade name, and it's not actually a ventilation system, it's more of a circulation system. Can you comment on that? Do you know what you mean by that?
I have relied on the technical evidence of Dr. Charles, and now I'm regretting that we let him leave the hearing. So I'm sorry, sir, I cannot answer that. Dr. Charles may be able to come back to you with an answer on that in writing post-hearing.
When I say ventilation system, I presume it is ventilation to the outside atmosphere, not just internally from the ceiling to the roof cavity. That's just like clarification on that.
All right, so I've made a note of that.
Thank you.
May I inquire, is there a timeframe which the panel would like a response from this, and perhaps any other questions we can't attend to today?
We'll continue, just check and see if there are any other questions from the panel first, and we'll get back to you on that.
Yes, good afternoon, Ms. Hepplethwaite. It's Commissioner McMahon here. I haven't got a lot for you. 3 areas of question. First one, well, not so much of a question, the policy framework that you've outlined in section 4. Thank you for that. Particularly the reference to policy 8. That's acknowledged, and the test there is to give effect to those policies, presumably, and the operative RPS. Does plan change number 1 to the RPS change anything in that regional space?
Not as far as I'm aware, sir. We did check that, and I was involved for another client in making submissions and providing evidence on it. So I'm fairly confident the answer is no.
Okay, thank you. Second topic is the useful information you provided in section 7.10 on your table of properties, or you comment on Miss Treadaway's table, and Miss Treadaway is now Miss Huser. There's a name change. So that was useful. Your paragraph 7.10b was subject to a lot of questioning this morning. You've from your own GIS examination, and I acknowledge you say it's not purely scientific, but it's what you looked at. You've said that 70 to 80% of the sites already contain buildings, and the converse is that 15 to 30% don't contain buildings. So that's the, I guess that's the pot of potentially affected for new builds at least. But would you also acknowledge that there is scope for additions and alterations, even on those sites that have buildings that may contain a habitable room or dwelling, habitable room or, that would be a sensitive activity.
Yes, most certainly. And I thought I had covered that. Bear with me, sir. I will just have a quick recap. I think I said somewhere in there that was like, oh, there we go. If I could refer, sir, please, to paragraph 7.11. And in my third line down near the end, I've said a secondary impact is a proportion, and I put in brackets here, unknown, but less than 100% of existing sensitive activities that may at some point have alterations which trigger noise insulation provisions.
Yes.
So I guess I'm saying I don't know how many people may choose to make additions to their activities, but I would be very surprised if every single property along the rail corridor chose to take that opportunity.
Yes. Would you acknowledge that the council in the notified plan for Masterton district at least has enabled greater density of residential development in the residential zone?
Yes, I'm aware of that.
That could lead to infilling or
yes,
additional habitable rooms.
Yes, I had a look at when I was perusing the aerial photos. I did have a look for properties which had larger sites, or perhaps the dwellings were located more closely to the front of the property, which, you know, but it's not scientific. It's a best estimate based on what I can see.
Yes, and we certainly acknowledge that, and I think Ms. Huser acknowledged that also. The last series of questions are just on your attachment A. Did you prepare the KiwiRail submission?
No, I did not, and that's why there are a few points, as I noted before, where I looked at it and said, no, I have a different approach than that.
Sure, okay, that's fine. There's nothing sinister in that question. I just wanted to understand how wedded you were to it. In terms of the maps, one of the questions that I put to the officers this morning was, and my questions largely focus on the noise control boundary as opposed to the vibration one, was the spatial extent of the overlay defined on maps in the submission? And the answer was no. And that it was through the definition of the metric of 100 metres outwards from the edge of the rail designation boundary. Can you just confirm that is the case?
That is my understanding. I did not see any maps attached to the submission.
Okay. We were told in answers to a question verbally this morning that the width of the designation varies over the 3 districts from 20 metres right through to 250 metres. And that means a variable RCN control boundary, which I just wonder whether that was the intention of the original drafter, that the boundary would could extend, you know, well, in some instances it'll be 120 metres, and in some instances it'll be 350 metres.
I'll answer an earlier part of your question first. In my experience, I haven't checked the absolute widths of the designation across the entire area of the plan, but I have dealt with a large number of similar hearings for KiwiRail across the country, and in all instances, the designation width does vary. topography, facilities, sidings, other things like that do make it variable. In each instance, my advice is that the 100 metres does extend from the rail designation boundary. It's a very clear and measurable location to bring the boundary from. Measuring from the tracks is commonly put forward. The tracks, however, can move, can be doubled up, etc. For the West Coast plan, which similar to yours is amalgamating a number of districts, that was dealt with either early this year or late last year, so I'm not quite sure which for this topic. One of the things that I assisted KiwiRail with in preparing its GIS files was effectively auditing the application of the 100 metre width. Dr. Charles is much more technically adept at providing an explanation of the modelling, but what that involved is effectively manually checking by aerial photos and back with KiwiRail's property team through Ms. Grimlington Hancock as to where there are anomalies, unusual shapes on the corridor, or we found spur lines or former spur lines which are actually no longer in use, or other sidings and things, whether there was a need to have the 100 metres extend from that location, or whether there were some land parcels, even though they're designated, that wasn't actually necessary or appropriate because there was no material effect to manage. And indeed, in Hokitika, there was an entire rail line which KiwiRail no longer owns, but which was initially shown in the draft maps as having 100 metres around them. But on further investigation, it was seen that it was definitely not appropriate. So yes, it's variable, but yes, there's also an audit process in place to try and limit anomalies and where it's inappropriately applied.
Okay, thank you for that answer. How would that audit process work in terms of the submission though? Because the request is to define the overlay based on that 100 metre dimension from a variable designation boundary. Unless there's some intervention between now and the decision being made for that audit, aren't we limited to giving effect to what's been requested?
Yes, it's never more than 100 metres, sir. It is only a case of going, I can give an example, a small spur line that is perhaps decommissioned and is never going to be used again, but the designation still covers it. There would be no 100 metre circle, if you like, around that. So it's a case of taking things away, not adding new things.
What's the process for that?
KiwiRail provides their GIS team, sets up the 100 metres from every designation boundary, and then I audit them, and then I go back to KiwiRail with questions, and Dr. Charles similarly makes an audit of that to assist with any anomalies or quirks that show up. As you can...
Yes, I understand that, but how does that interact with the process that this panel's dealing with? We will be issuing our decisions on the plan before local body elections.
Yes. Must apologise. I am not certain if there have been any draft plans provided to you, but if there have not, we can provide those after they have been through that audit process.
We don't think there has been.
Right. All right. So most certainly we can get back to you with a time frame as to when they will be available, and I can assure you that they will be checked by both myself and Dr. Charles and provided to your staff for their review as well. So if there's any questions, they can come back to us.
Okay. I'm conscious of time, so I'll push on very quickly. Can I just now go to S4?
Yes.
And thank you for explaining the three pathways. I didn't quite understand that in this morning's conversations, but I understand them now. I had focused on pathway A and pathway C. I now see there is a pathway D that involves a noise barrier. And these are ors, aren't they? They can the recipient,
that's correct. Yes.
can choose. The recipient can choose. Yes.
Yes.
Okay. The noise barrier, might that require its own consent as a structure?
It does not have to be. It could be something that's already in place, sir.
Yes, but if it's not?
If it's not, yes, I would imagine at 3.8 metres high, it's possible that a barrier would require builder consent. Not my area of expertise, but I understand that a large number of structures do need consent.
Yes, but not just building consent, possibly land use consent.
Yes.
If it's side yard, rear yard boundaries, that sort of thing.
Yes, quite possible. Yes.
Okay. Okay, and is the that's fine. No, that's fine. My final questions are more sort of philosophical. One of the benefits of hearing from Mr. Arden and Dr. Childs is that it's clear to the panel that in achieving the 40 or the 35, depending on what the activity is, based on the predicted levels, nothing within a 100-metre distance will actually comply with S4, and there will need to be some sort of resource consent required and lodged. Is that your understanding also?
Most of the standards are permitted activity standards. So
yes, I know.
if the
Sorry,
building...
let me rephrase the question. It's unlikely that any of the permitted activity standards would be able to be complied with without some form of attenuation to achieve the specified outcomes inside or outside the building, 35 or 40 dB.
I think that's my understanding, but it would probably be best addressed by your noise experts, Sue.
Yeah, well, it's a planning issue, really. And I think certainly Mr. Arden confirmed that, and I think Dr. Childs by default had confirmed it. So if those standards are not met, there's no longer a permitted activity, and would default to a restricted discretionary activity, I believe.
Yes, that is correct. If the standards were not met,
Yes.
And if the standards are met, obviously it's permitted. Yes, that's the flip side.
I mean, the standards require 35 or 40 dBA at 100 metres based on 2 trains in an hour average. The likely predicted level was going to be 56 dBA. And even if you took it down to 1 train over an hour, it's only a reduction of 3 dBA, which is 53. So it's highly unlikely that any developments, whether they're new builds or additions of habitable rooms, would qualify as permitted activity and wouldn't certainly wouldn't get through clause 1A at least.
So I think if I understood correctly, you're saying without mitigation they wouldn't comply.
Without mitigation.
Okay, thank you. Yes, I think that is my understanding as well. Yes, in regards to listening to Dr.
And the mitigation is in 2 forms. One's it's acoustic insulation, and the second is where there's opening windows, mechanical ventilation.
Yes, correct.
Yes. And it may be that modern construction methods and techniques might assist with the acoustic insulation, but mechanical ventilation will be something that needs to be invested in.
Yes, if there are habitable rooms which are on the side of the building facing the rail corridor, if they're, if there's a garage or a laundry on that side, then those requirements won't apply.
Yes. So, there's a reasonable expectation that there will need to be resource consents, and even if there's not, there will need to be some form of compliance certification that would be required. And one of the pieces of information that came in from KeyRail put the certification around $3,000, and the costings were between 1% and 3%, depending on which report, the Taylor report and the Insight Economics report commented on that. Yeah. Okay. Okay, I understand that a lot better now. Finally, the issue for the panel was the risk of acting and not acting, and that includes the comparison of benefits and costs. And as I said to Dr. Childs, the benefits are understood and are possibly agreed. It's actually the costs that are a matter of contention at the moment between Ms. Schuster and yourself, and that's really where the panel have to focus their efforts. Is there anything you wanted to say in relation to that matter of acting versus not acting?
Yes, so there was just one thing that came to mind while I was listening to that discussion, and that was consideration of the life of the buildings that are constructed. And we've talked a little bit today, or I've listened about the life of the plan, approximately 10 years pending ORM reform. But when the buildings are built, you heard Dr. Charles describe that is the most cost effective and most convenient time to do the mitigation works. And I understand my experience is that buildings are supposedly to survive for a minimum 50 years under the Building Act. So I think when thinking about costs, rather than thinking about the life of the plan, in addition to thinking about the life of the plan, it's probably also worthwhile to think about the life of the housing stock. And as I move around Auckland, where I'm based, I'm often seeing buildings of 100 years old parked up there, and I'm quite certain I've seen similar buildings in the communities that you were there as well when I have visited the area. So it's for me, it's more than the life of the plan; it's actually the life of the building which people will get the benefit from.
Thank you for your answers.
Can I just add on that one as well, sir, through the various discussions that we've been having, which I'm sure you're aware of, the risk or not of acting is per section 32, just where there's uncertain or insufficient information. Yeah, certainly. And you'll be aware, obviously, KiwiRail's position is that, we would say there is sufficient information and it's more of a cost benefit analysis, but just wanted to
that's understood. That's certainly not the position of the officer, though. There's some
understand.
Yeah.
Absolutely. Yep. Thank you, sir.
Anything else from the panel? Any of the... Just like to thank you all for your time this afternoon. I know we've sort of had lots and lots of questions, and this has taken up a lot of our thought process for today. And we just really appreciate the time that you have given us this afternoon. So thank you very much. Appreciate it.
Thank you all.
Madam Chair.
Appreciate the discussion.
Okay. That does bring us to the end of our submitters today. NCTA did confirm that they wouldn't be presenting. Yeah, if we just have a 5-10 minute break, we'll just have a 5-minute adjournment, and then we'll come back to do the wrap up for today. Thank you.